And welcome into Queen City News Plus. You got Brien Blakely here.
Chief Legal Analyst, Khalif Rhodes.
Always good to see you, my man.
It is.
We got order in the court today, but shouldn't we say for the first one, topic of three ones, should we say odor in the court today? Because we're talking about North Carolina State Supreme Court is going to hear arguments if smell qualifies as a reason for probable cause with police.
Man, this one had me first because when our the news director sent this out, I thought he was talking about us. But then when you look at the title, though, right, odor in the court, it made me laugh because I had a funny story, and I'm gonna throw it in there quickly. When I was on the bench and I ran my docket, we small courtroom here in Mecklenburg County, not that big, and they'd usher everybody in there, but the holding room was huge, so 1,200, 1,500 people sitting out there. When they pushed them into my courtroom, maybe 15 could fit in there. Real small, real intimate, right? And I remember this one time, I'm sitting up there, and I'm just looking at my paperwork, getting ready for them to bring the next group in. I was like, what is that smell? Because they brought the folks in, and I'm like, okay, this is not right. And I look at my deputy, and he's looking at me. And I'm like, I know I didn't smoke anything. He's like, he didn't smoke anything. So he brought the group in on the left, the group on the right. He was like, okay, you guys leave. We narrowed it down to like that side of the room, and we moved the folks out one by one.
Oh, my gosh.
Until we figured out where the smell was coming from. It was that strong. So then I remember the guy was like, the deputies came in, they had him empty his pockets, and sure enough, he came into my courtroom with a bag probably about that big stuffed in his pocket. So odor in the court, specifically marijuana. Yes,
well,
I know
was that
like
marijuana or was that hemp? And that is the question. Yes, that we're dealing with today here in North Carolina, because we got three cases that are focused on illegal marijuana up against legal hemp. And defendants argue because hemp is legal in North Carolina, the sight or smell of the alleged marijuana does not give police the probable cause anymore.
I'm one of those attorneys that's going to make that same argument. Let's be clear. We have a couple things. Fourth Amendment it stops you from being able to be searched, unlawful search and seizure, right? And so typically a search without a warrant is going to be per se unlawful, meaning it's unconstitutional. The only way they can search you is if they have probable cause or if they got a warrant or if you give them consent. So the automobile exception is the one that we can talk about where in the vehicle if there's probable cause. So what does probable cause mean, Brian? It's that it's more likely than not that a crime has occurred, and that you have reasonable suspicion, that you have other facts to support that, because you got these standards. Reasonable suspicion is underneath there. Probable cause is right above there. Once you get to that level of probable cause, now they're able to say, I can search your car and I can search it for drugs. So how do you base your probable cause? What are you using to base your probable cause off of? Well, in this scenario, most of the time it's going to be off of the officer's history, off of their training, because the officers were writing the affidavit based off my experience, based off of my years of doing this. I believe what I saw. I believe what I smell. I believe what I observed.
They've actually had training courses to go smell the difference between marijuana.
They do. And it's not just the difference. They're going to these trainings like a DWI training like I've been to, the same as officers have, where it's teaching you how to just know what just marijuana smells like, period, right? But the issue is, and this is what the court addressed, the question presented before the court is not whether an officer can discern the difference between marijuana and illegal marijuana and legal hemp, but rather, based on the officer, his or her training and experience, did they have reasonable grounds to believe that the suspect possessed marijuana? How can a person that can't distinguish the two, the difference between the smells, because as the court has indicated here, SBI report says, all scientists say the two are indistinguishable. So how can you take a person, an officer, and say, you know what? Based on your training, based on your experience, you now, even though science says you can't, you can distinguish between the two. And why I think that's important, Brian, is because if I have legal hemp, if I am now traveling down the road doing something that is lawful, technically, you should not have a right to be able to stop me, period. What the court is now saying is that an officer can stop you even if you're having something legal on your body, on your person, in your vehicle. And I think that's a violation of the Fourth Amendment because it prohibits unlawful search and seizure. If you can't justify it with probable cause, you have no authority to stop me. And the court is now saying, well, they do. And it's not because they can't smell it, but I argue that the only way they can tell if probable cause exists is that they had to smell it. It's not. I mean, even if you saw it, you can't distinguish the two between sight
Right.
or smell.
The hemp is right up against the legal limit there because it goes up to the Delta 9, which is the illegal, to Delta 8, which is the legal version of hemp. But the officers are saying that they can smell the difference.
Those officers are not accurate. I'll say this. There's not a scientist on earth that does this type of work. And that's why SBI, the State Bureau of Investigation, sent out that memo in 2019. They sent this to the General Assembly because they recognize, hey, you're going to set us up for a problem. While you're legalizing hemp, I need you to recognize that you cannot distinguish between the two. And because you can't distinguish between the two, officers are not going to have probable cause. The judge in this court, they looked at that memorandum and they used that as the basis for their argument. I think that the judge got that right. I think this panel of judges, our Court of Appeals judges, got it wrong. Specifically, they took it personal that the judge used SBI memo as guidance. They said that the court is the ultimate trier and decider of what the law is, right? Like kind of Judge Dredd, I am the law, right? As opposed to, yeah, that's great. That you can say that, but you still have to be able to understand what the science says. And what the science says is you can't distinguish the two. They've made an opportunity to say, well, we don't care about the smell. They're using their experience. I like that argument, except for their experience is based off of smell. They're not doing anything else. What other experiences
you don't have any field tests to do it with? Yeah.
Right. And even if they sent it to the crime labs in North Carolina, they don't even have the test to be able to describe and say, look, this is different. Those are all the problems where we're running into with this, and they've opened the door for a number of challenges. This attorney in the district court level did the exact same thing I would have done. We're going to file a motion to suppress. You stopped, and the officer's affidavit said all the time, strong odor of marijuana. Okay. Now you write strong odor of marijuana, you've subjected yourself to a motion to suppress. All this case is saying now is if the district court judge suppresses it, they may be able to appeal it to Court of Appeals and get it overturned.
It is a good conversational piece because also what was found in one of these cases were scales and a handgun. Now, the observant here who's done many news stories, when someone finds scales that says, hey, that says drug dealer, that doesn't really have the legal standing, but it does say, look, you're up to no good in some ways.
A couple of things, Brian. I'll say this. And so that will go to the court's the argument with it based on his training, his or her training and experience. But the problem with that is you don't find the scales, you don't find all those things until you get into the car. So if my basis for the stop, what legitimizes and makes my stop legal is that I smelled it, I now can't say, oh, but I'm going to transition it to now I found these things to justify the stop. The probable cause has to be there before you. Now, if you saw this scale sitting on the dashboard, if you saw individual baggies sitting on the dashboard, I think that's probable cause that for a stop to occur because those are clear signs of attempting to sell, possession with intent to sell, deliver. I don't think if you not seeing them and you're driving by and all you do is smell the odor by a person's car, I don't know if that's going to be enough, but this court is saying that the officer can use that totality of the circumstances as enough to get their basis for probable cause. I just think it opens the door for a lot of challenges and a ton of litigation.
How does this affect any cases going forward for those people that are in prison right now who have been convicted of these type of things, if they do rule in favor of the defendant?
This won't be retroactive. This is a moving forward type of thing. So moving forward, after the case came out in 2024, State v. Parker, it was going to be the same way. Anytime you get one of these type of cases, now you as an attorney, the very first thing you're doing is you're filing a motion to suppress if you see strong odor of marijuana. You're saying, nope, I'm going to suppress it. And then if you suppress it, it's dispositive, meaning if they don't have the evidence of the marijuana, the case gets dismissed. So I'll file the motion. Worst case can happen. The judge rejects my motion to suppress. Okay, we move forward. Best case scenario, the judge accepts my motion to suppress. The case is over. So you'll see more folks doing that based on that original case. Now, this other case gives prosecutors and folks in the Attorney General's office an opportunity to appeal those cases when they're dismissed, but they don't have the numbers. And so while they may one-off have done it with this case, if there are a number of attorneys that are filing these type of challenges and motions to suppress and winning, they don't have a manpower to file this in the 100-plus jurisdictions that we have in our state. So I don't think it has much of an impact, this decision. I just think it gives the court and law enforcement mixed guidance. Because now you have officers out there still saying, I smelled it, and the very first thing we're doing as defense attorneys, It's following the motion to suppress.
All right. Well, there's going to be a lot more going forward about talking about this case for sure, and it's also ramifications going forward legally for a lot of people in the state of North Carolina as it goes to the Supreme Court. We're going to wrap that one up. Next topic is going to stay with the Fourth Amendment here because we're talking a lot of Fourth Amendment here today in North Carolina. Khalif, we're going to be talking about Durham going to be a sanctuary city. They have announced that, and we'll have much more on that. You're watching Queen City News Plus, Order in the Court with Brien and Khalif. All right, welcome back to Queen City News Plus. We've got Order in the Court here with Khalif and Brien. Second topic today, we're going to stay with the Fourth Amendment stuff here. Khalif, Durham just became the second city in the Triangle after Carborough to pass a Fourth Amendment workplace resolution, which is dealing with the protections of unreasonable search and seizures, and basically talking about they're going to be a sanctuary city.
I can say this, Brien. We are not proactive with our approach to laws. And that's statutes. That's
you took your time on that,
right?
Counselor.
Well, I want to make sure I'm giving us the best response. That's clearly weighted in my thoughts because I have a lot of thoughts about this. But I say this all the time that we are super reactive with our laws, with our statutes, with our codes, with anything that we do. Think about our exit signs, right? That we have when we go to clubs or we go into buildings. We have those because in the 80s and the 70s. Folks were getting caught in fires, specifically in nightclubs, and they had no signage. And then lots of people died. And what happened? These states and the congressional side said, you know what? We have to figure out a way to change that. So reactively, we reacted to a response. It's rare that you'll have the lawmakers in front of something and say, you know what? I anticipate this is going to happen, and so now I'm going to create a law. Well, what is this right here? We have the administration with the Trump administration that's openly said that we're going to try to have the most deportations in the history of this country. And you've seen an increase of ICE members, ICE raids, and ICE
Mountain
scares.
This summer at a plant there, yeah.
So you're seeing this elevated presence of ICE all over the country. And North Carolina is a location where you're seeing an increased presence of ICE, right? And then you're also seeing a community that is looking to try to find a way to continue to thrive and work while not being under the weight of fear, the fear of going to work, the fear of being in a community you've lived in for years, and now you don't know if you can go to work tomorrow. Those are the types of things that bring about something like this. So what do you have? You have an ICE agent a couple months ago that goes into a Durham County courthouse, sparking protests, sparking fear in the immigrant community. And so now Durham is saying, okay, in these public places, we're going to pass this Fourth Amendment right to workplace safety, that in these locations, unless you have a warrant, you cannot come into here to arrest someone. And that is legally something that can be done because what you have is these officers that are going in places and they don't have a warrant to grab you. They're just picking you up off the road, mask, plain clothes, plain cars, unmarked vehicles. Those are the types of things that happen. And if you really think about it, those are the types of things that happened in Nazi Germany. Those are the types of things that happened in places where there was no really rule of law, where that fear ruled the day, and that average people were concerned with just making sure they weren't picked up. If you can be picked up without a warrant, thrown into a cell, held forever, and not have any access to due process, that's not the country that we talk about and fight for. And soldiers go.
It is the country that we are in today.
It is.
And, Mayor Leonardo Williams of Durham says he's standing up for due process. The unanimous council resolution is aimed at protecting city workers against the ICE raids or arrest. But he's making it clear here that it does not stop ICE from doing its job since the city does not have jurisdiction.
Not about blocking ICE, but about reaffirming rights. That's what they've talked about a number of times down there, emphasizing that there is a humanity aspect that has to occur, and there's a constitutional portion that has to occur, specifically the Fourth Amendment. If you are attempting to come into these places where you need a right to come in and to arrest, you need a warrant. That's what they're saying. Now, on the other side, I can say that these are public buildings. These are locations where you don't need a warrant to walk into. But what they're saying is, you're going to need a warrant before you can come in there and conduct business. That is going to be the problem that we're attempting. I mean, you saw this with the sheriff departments across our state where they have now made sheriffs force comply with ICE requests for cooperation. Well, this is a scenario where in Durham, they're saying we're not going to cooperate unless you have now lawfully went and got a warrant to force us to cooperate.
And, we'll have to see what the Trump administration, how they're going to respond to this, because we've seen that next up is Chicago as far as taking over the police force there. I had an immigration raids there. But Durham now putting itself in the spotlight and also the bullseye for the Trump administration. That's something we'll watch going forward.
It is, Brian, but let's be clear. President Trump most recently said that he has said that AI generated image of him with the Apocalypse Now theme, and he says that he's going to show them why they changed the name of Department of Defense to Department of War, right? And that sounds all great. But when you have people that are in the city that the crime rate is going down 35% over the last year, this is Chicago. You have folks in a place where they are actively doing it on a local level, trying to figure out not just programs, but solutions to problems that have been going on for the last 10 to 20 years. Saying that you're going to bring in the military, again, things that would be a violation of our law, to come in there to police when they can't do that. Now, if there is a attack and a threat, yeah, there's protections for the president to do that. But if you're attempting to police local jurisdictions, cities, municipalities, counties, and towns, I think that we're going to have problems. And Durham is saying, before you can move and do that here, we know that that's the next step, and we're going to proactively stop something like that from happening.
All right, we're going to leave that one there right now, but we will still continue to talk about President Trump coming up in our next segment, and the person who was charged right now with trying to assassinate President Trump last year in Florida appeared in court today as his trial opened up, but he's also representing himself, and we'll talk about that coming up right after the break when we're watching Order in the Court on Queen City News Plus. Welcome back to Queen City News Plus. You're watching Order in the Court with Khalif and Brien here today. Third segment we're going to be talking about is one of President Trump's, the guy that was trying to assassinate him last year on the campaign trail. This was when he was in Florida. He was on the golf course in Palm Beach. Ryan Ruth, North Carolina native, started his trial today for the assassination attempt on President Trump. But he's also ruled today that he can represent. It looks like for him, but is it really a win for him?
Absolutely not. So let's go back and say a couple things. The judge, you may be familiar with the name Eileen Cannon. Why does that name sound familiar? Well, she's the judge that was overemphasizing that, not is, but was overseeing the Trump documents case down there in Florida. Why it was and not is? Well, because she's the same judge that dismissed the case. Now, she's got a lot of pushback over the years because of a few things, specifically that she has a lack of experience for this level of court. She had not been practicing long, had not been on the bench long, and then was quickly and swiftly appointed to this position and confirmed. Now, the problem with that is that judges like to dictate and run their courtroom. And when a judge runs their courtroom, first of all, no judge wants to be overturned. But second, they don't want their courtroom to become some circus. They don't want it to be made of a mockery. They want to ensure that what's happening in there is efficient and effective. And so the first thing I'll talk about is before we got to jury selection, the judge allows him to represent himself. Okay, red flag already. Yes, he has a constitutional right to representation, and he has a right to represent himself if he chooses. But every judge that I've ever clerked for, ever worked for, and ever been in the presence of, when a defendant wants to do this, will basically do everything within their power to stop that defendant from doing that. And they'll give them the warning, hey, I got to treat you like every other defendant. I'm sorry, I got to treat you like an attorney. I can't babysit you. I can't hold your hand. Whenever you walk through this process, you recognize that you're going to be going up against a person that's went to law school, kind of giving them the nudge in the push to recognize that, hey, is this an idea you fully thought out? And if you haven't fully thought it out, okay, I'll keep this attorney here. And then if the judge is, after all those questions, if the judge is still not satisfied, they can have an attorney stay of assistance and of counsel. We had that here last year with the homicide trial. The guy wanted the case on his own. The judge, Judge Archie, was not comfortable with that. And what did they do? She made the attorney stay there and assist. So that's the second step. The third step is, all right, we'll just fully remove your attorney. In this scenario, that's what's occurred. And now we have a rocky start. Jury selection begins. And even after she gave him a warning saying that it can't be calculated chaos and that the set of rules are strict, he starts asking crazy questions that are outside of the bounds, questions that are political, questions that you typically would not hear in a courtroom for jury selection that are irrelevant. Trump buying Greenland? Palestine, turtles on the road. Those are the type of questions that this man was asking today in jury selection. So
he's getting his point across in some ways about his feelings out, but it doesn't really help his legal standing in this case.
It doesn't. And I can tell you this, it's a problem. And so this is what a more seasoned, right? A judge that has some type of marination, right? They've been sitting in the refrigerator a lot longer, and now you're ready to put it on the grill. That's what a seasoned judge would have avoided. They would have went through all of the steps to avoid this, because now this has turned into a circus. Even though you gave the comment that you don't want it, it's costing folks time, effort. Something that would normally take a few days for a jury selection like this may take a week. Why? Because you're going to have somebody that's making a mockery of the system. Ultimately, she probably will bring another person on to assist, someone to advise. But he had said that he didn't want his attorney gone. Why? Because they were miles apart. That he was on one side, the attorney was on the other side, and he wanted the attorney to get off the case because they were never going to see eye to eye. But when you're dealing with people like him in these scenarios where they're charged with these egregious crimes, it's hard to be on the same page. Oftentimes, they have far out thoughts in terms of how the law works and how a case should be moving forward. His attorney is like, if I'm in that scenario, I'm saying, I don't have any problem getting off the case, Your Honor. It's going to be harder for me to get off because most of the judges don't want to let you off. So that's why I said, and this is not an attack on her, but I can tell you this is something that it is rare that a judge is going to let an attorney off of a case, even if the client is begging, unless it is like they are fully informed of what they're doing.
The judge putting herself in the spotlight herself once again in something like this. Have you ever had some guys, people that you've represented that say, you know what, I want to represent myself?
Absolutely not. So I can say I've had folks that may not be happy with my representation and may like, you know what, I'll let me start with this, Brien. Anytime a person hires me, I tell them that this is a relationship. This is a marriage. That your decision to select me as an attorney is not just one way. That I get a number of folks that come and call me for a representation, and I don't accept every client, even if they have the means. Why? Because I got to go into this relationship with someone that I can see myself working with. So if I go and take every client, it may be a bad date, and I can't swipe left once I'm in there and get out of this relationship. So I do the due diligence up front. I want to talk to you. I want to know what your family looks like. I want to know what your people, your spouse looks like. I want to make sure you're not someone that is going to make this a headache, because the case itself is already enough. I don't need you adding and making it a headache. So I oftentimes say, thanks for calling. Thanks for your request for me to represent you, but this isn't going to work out. Have a good day. But every once in a while, one squeaks through the cracks, and it's hey, you went through, you vetted them, and then somehow they still were, the relationship just, you're just not doing enough, and you can never meet the expectations. And then you're like, if a client is saying, I no longer want to move forward, you're saying, thank you. I'm happy, because it's like, you know what? It's not you, it's me type of scenario. I'm glad you said it before I said it. That's the type of thing that I have been in, but never that scenario where they want to represent themselves, specifically with a attempted murder trial, because this isn't like jaywalking. This isn't a misdemeanor case.
He's facing life in prison.
He's facing some significant time, and guess what? You don't want to be going in there against a DA, against a U.S. attorney that has been doing this for their whole life, and you've never done this once.
Yeah. All right. We're going to leave that one there as well. But a case that we will certainly keep following here on Ryan Ruth going to trial for the attempted assassination of President Trump. Thanks for watching today. Khalif, always good stuff with you. Appreciate you.
Always.
Yeah. You've been watching Order in the Court on Queen City News Plus.
Queen City News Plus. Just search Queen City News on your smart TV's app store.